All right, I think we're going to get started. So again, thank you, everyone. Good afternoon, and thank you for being here. Welcome to our first in our exclusive estate planning webinar series. My name is Jeff Elastigui. I'm the founder and managing partner of the Legacy Group. On behalf of everyone in our firm, thank you for joining us this afternoon. The Legacy Group is dedicated to guiding individuals, families, and business owners through comprehensive estate planning strategies. Our servers-first approach ensures that every financial decision is intentional and designed to safeguard your future. This series reflects our commitment to our mission, which is to help you live a life of greater confidence, choice, and financial freedom. Today's discussion features a panel of esteemed financial and legal professionals, each bringing a wealth of knowledge and insight on how to build a sound estate plan. First, I'll introduce my business partner, Robert Sturgis, who is a financial planner specializing in retirement planning, wealth management, and business strategies. Next, Evan Rodakis, who is our Director of Financial Planning. Evan is our in-house counsel with an area of expertise in estate planning, asset protection, and business succession planning. Our guest speaker today is Mary Ragunahan, Head of Estate Planning Department at Kaplan, Dittrapani, Faria, and Mannin. They offer a comprehensive guidance in trust, probate, and asset protection. Each of our panelists here today will provide a valuable insight to help you navigate estate planning with confidence. This four-part webinar series is designed to build toward a complete estate planning strategy. Each session is structured to offer practical guidance and actionable strategies, helping you make informed decisions as you go through your planning process. We encourage active participation. So if you have any questions at any time, simply raise your hand or drop a comment. We'll do our best to address any questions that are coming in throughout the presentation. Before I hand it over to Rob so he can get us started, one of the things that I was reflecting on the other day is a common theme that I've experienced with my clients over the last 23 years, and that is most people, even if they've done planning, they experience a certain level of frustration with the lack of coordination that exists across all of their advisors, right? So even if they have an attorney or an accountant and financial planners, oftentimes what happens is there's no communication, and that lack of coordination creates a lot of uncertainty. So if that sounds like you, I think you're going to enjoy today's presentation and the next three, because it's going to address a lot of those concerns and perhaps frustrations that you felt in the past. So with that said, I want to hand it over to Rob.
Thank you, Jeff. As you're going to see here on the agenda, I think we have a very important topic that we're going to be focusing on today. First and foremost, I think the most important part of this is just answering what estate planning is. Our two esteemed panelists are going to go through in their own words what estate planning is, discuss with you important documents that you should have for your own planning. More importantly, they're going to touch base on what happens if you do not plan. I think this is a key topic that you're going to see Mary has a lot of passion in, and how do you strike up this conversation with family members and loved ones? And we do plan to make time available at the end to answer any questions you may have. As Jeff mentioned earlier, if you have questions throughout the presentation, please write them in the chat. We will try to address them as quickly as possible. So with that being said, first and foremost, Evan, in your own words, what is it that estate planning is?
So estate planning is more than just wills and trusts and a few other documents we're going to talk about a little later. It's really it's an intentional decision to make what do you want to happen to your assets upon passing, and how do you want those assets to be distributed to those loved ones or charities that you may care about.
Great. And, Mary, in your words, obviously, Evan gave a great detail into what estate planning is. But what are some of the most common misconceptions that you've experienced that people have about this topic?
A lot of people hear the words estate planning and they assume it only applies to the ultra wealthy. But the truth is that if you have loved ones or you own something, whether it's several homes in and out of state or a single primary residence, multiple investment accounts, or even just one joint bank account, you have an estate and that deserves protecting. And proper estate planning offers that. Estate planning isn't about how much money you have. It's about making sure what you do have goes where you want it to go, and that the people you care about aren't left scrambling in a crisis. So one of the most common misconceptions that I hear a lot is, as I just said, only the wealthy need estate planning. And throughout this workshop, some of the very important considerations you may want to contemplate for your own legacy planning beyond just assets alone will become more clear. Another common misconception about estate planning is the belief that I'm too young to need an estate plan. Unexpected events can happen at any age. Having a plan ensures that your wishes are honored. Life doesn't always give us a warning. Anyone age 18 or older is legally considered an adult. This means that even if your close parents, partner, loved one, even if you have close loved ones, they don't automatically have the legal authority to make decisions for you in the event of an emergency. So without certain legal documents in place, like a power of attorney for financial matters or a healthcare proxy for medical decisions, no one can step in on that person's behalf without court involvement, not even mom and dad. So unfortunately, even young and otherwise healthy individuals can get into accidents too. They can have life throw them a curveball as well, or fall unexpectedly ill. And I think it's normal to not want to focus on the things that we don't want to have happen, not to ourselves, and especially not to the people that we really care about. But having the foresight to include certain documents like the ones I just mentioned can prevent delays, hefty legal fees, and avoid family conflict during a potentially unexpected and typically very emotional time. Moving on to another common misconception about estate planning is that I hear a lot people say, believe that a will avoid probate. However, a will actually goes through probate, which can be time consuming and expensive. Evan will provide more context on this later in the workshop, but for now, just note that a trust is a commonly used tool to help bypass the probate process altogether. Make no mistake, wills are important. They are a vehicle to appoint your preferred guardian if you have young kids, and they allow you to distribute your assets in a way that circumvents the state's intestacy laws within certain limitations. However, they are subject to probate, which is a legal process where a judge supervises the distribution of your estate. That process can take months or even years, and it becomes public record. Wills also have more potential to be contested. So while wills are useful and often necessary, they're not the whole picture. They come with certain limitations, and especially when it comes to time, privacy, and control, those are some of the major limitations within them. And that's why people look to tools like trust to create a more seamless plan. So now that we've cleared up what a will doesn't do when it comes to avoiding probate, let's talk about what happens if you don't have a will at all. So there is a misconception is if you don't have a will, the state gets your assets. And while the state won't automatically take your assets, intestacy laws will determine who inherits them, which may not align with your wishes. The state doesn't just take your money, but it does take over the decision-making. If you die without a will, state intestacy laws get to decide who gets what. This default plan may leave out people you care about, like unmarried partners, stepchildren, close friends, and you lose the ability to choose how, when, and to whom your assets are passed. In some very rare cases, if there's no legal heirs at all, the state can inherit, but that's not as common. But the bottom line is if you don't decide, the state will decide. And finally, we'll address one of the biggest barriers that stops people from exploring planning altogether. And one of that is that they believe that estate planning is too expensive. And
We have, sorry to interrupt, Mary. We do have a question, I think, that
Oh, yeah.
pertains to the probate part that we're, and Evan, this is all for Evan too, but we have a question that says, how does the cost of probate compare on average when compared against the cost of an annual cost of managing a trust? So that's, I think, a very specific one, but you guys have any idea, Evan?
Sure. Great question. In New York, probate is not a terrible process. It has this spooky kind of connotation with it because in other states, it is horrible. Florida being the main one for a lot of our snowbirds out there. And, I'm not sure who goes where on this list, but Florida does have an arduous process of probate. New York is not terrible. The upkeep of a testamentary trust, and I'll talk about different trusts in a little bit to give everyone a high-end view. But there is no real annual upkeep cost for a trust that's created to avoid probate. Really, the initial costs of creating are moving the homes, which are not usually all that expensive, but there is an additional cost to creating and filing a deed in the state of New York. Other states might have different costs, but there's always a few dollars to change a deed in ownership.
Thanks, Evan. I appreciate that.
Great.
Mary, you just did a great job giving certain misconceptions that people have as to why they delay their planning. But assuming everyone at this call has decided, you know what, I need to get on my planning right now, what would you say the 4 main pillars are of someone looking to start an estate plan?
Yeah, okay. So I would say that one of the primary things is to understand the purpose of why you need an estate plan. And again, estate planning isn't just for the ultra wealthy. It's about making your wishes known, protecting your assets, and caring for your loved ones. The purpose of estate planning is to encapsulate everything you built and everything you value and protect it. And I think of an estate plan as a love letter to yourself and the people that you care about, honoring the life that you've built while also protecting your loved ones and ideally preserving your legacy and intentions from beyond the grave as well. And so you also need to recognize the risks of inaction. And so, as I mentioned before, without a plan, the courts decide, not you. And that alone is a huge risk. But we can bring this even closer to home. Have you ever stopped to think what you would do if one day you woke up and life was just different? Different in a way that you could have never predicted. Not theoretical, not distant. It's personal, immediate, and real. And I know that that can be a daunting thought because it reminds us all of how much we can't control. But what we can control is how prepared we are. And that preparation can be the difference between chaos and clarity, between losing everything and protecting everything you've built, everything you love, and everything that has meaning to you. With the right planning, we protect ourselves, our loved ones, and everything we've built, even if it's modest, even if it's messy, it still matters because it's yours. And so when we don't plan, we risk losing our voice, losing our choice, losing our privacy, our dignity, and sometimes a significant portion of the inheritance we intended to pass on. And I've seen firsthand adults and children end up in costly guardianship or conservatorship proceedings, children placed with estranged or unprepared relatives or becoming wards of the state because no legal guardian was named, spouses or partners who are left unable to access assets or even refinance a jointly owned home, families who are forced to prove in court that they're the right person to care for someone they've loved all of their lives just because there was no estate plan. And it doesn't always stop there. The courts demand evidence. Notice must be sent to every possible relative. People who were never part of the day-to-day suddenly have a voice, and sometimes they contest everything. And now that can develop into litigation. And so then there's more legal fees, more court delays, more emotional stress, just to step in and help someone who would have wanted you to be the one to be the one who was helping them. And so even something as basic as accessing a bank account can turn into a legal battle, because being married doesn't automatically give you control over financial or medical decisions. And legally, your spouse must have capacity to name you as their agent through proper estate planning documents. And so no financial power of attorney, maybe that means no access without a court order. And even when it comes to property, if your spouse can't sign and there's no plan in place, even refinancing your jointly owned home may require a court petition. And all of that takes time, money, emotional energy, and a whole lot of unnecessary delays and stress. And I haven't even touched on the complexity that comes with owning a business and being part of a partnership or holding shares in a multi-member entity. That's a whole other layer we'll explore in an upcoming workshop. But when you wanna put the right tools in place, from wills and trust to healthcare directives, the right documents ensure that your intentions are protected legally and financially. And I think at this point, we've laid a pretty good foundation for why planning it matters, but none of that works without the right documents to support it. So anything from having a healthcare directives like a financial power of attorney or a HIPAA authorization, these are tools that give you the plan, the legal and financial structure that work in real life in your favor. And it's one of the most helpful things you can do for yourself and for the people who may one day need to step in your behalf, because it reduces confusion, it prevents conflict, and it gives your loved ones a clear path forward in what might otherwise be a difficult time. And so
Mary, I hate to jump in, but in the interest of time, knowing that the next topic you're going to discuss being having the right conversations, that's going to be one that we're going to dedicate a few slides to later on.
Yes.
So what we'll do here is just kind of move forward, just because I want to be respectful of all of our attendees' times. But thank you so much for all of your passion.
Thank you.
Evan, if I could ask you, now that we've discussed why you need planning and what the pillars are, can you please go over what the components to a comprehensive plan?
Sure, absolutely. First one is going to be the last will and testament. And we keep jumping around there. And let's talk about what a last will and testament is. And I'll give a little more meat. And if there are questions, throw them out there and I'll definitely try to address them. Last will and testament is exactly what it sounds like. It is letting the world know what you want to happen to your stuff upon your passing. All right. It could, for a lot of families, especially younger families, the most important thing in there is the guardianship. All right. So if you have children that are minors, this is where it definitely comes in to say, this is the person I want to raise my child. And that's a massive decision for most families. Other items that come in kind of interplay with some of these other boxes, like the next one would be trust. People think of the word trust and their mind goes directly to multi-million-dollar or even more entities that have, again, some sort of connotation in common culture about trust fund babies and all this other stuff. It's really not the case. They are a useful tool. There's three main types, and I'm going to give them to you right now because there's no reason to avoid it. There's revocable and irrevocable. When someone is trying to avoid probate, you're going to put the assets in a revocable trust because those times, I'll back up a second. Probate it just means Latin to prove. That's all it means. And you're proving that the last will and testament was accurate. When you have items that are owned or assets that are owned by a revocable trust, so again, the person creating it is the person in charge who can also amend it, they will be able to avoid the probate process because the trust owns it and the trust survives the passing of that individual.
Evan, if I could jump in right there, we had a follow-up question previous with regards to probate, and I think it's a good time to answer that. What is the typical time that it takes for a will to pass through probate?
I am going to have the worst lawyer-like answer and say it depends. Not going to punt the question, but it depends on the county that you live in. So I've seen simple situations, husband to wife, husband to husband, wife to wife, everything down to children that are adults. I've seen it get through Suffolk County here in New York. couple months, not really all that crazy. And then I've had cases in Queens where it took a year and a half and it was not that complicated. So it's a terrible answer, but it really depends. I keep using Florida as that other alternative just because we have a lot of snowbirds. And Florida probate, you're talking a minimum of over a year to get all those assets down to the next generation. So it could be definitely a problem in other states, or at least out in Florida is my experience. I don't have a ton of experience with other states, and then even more so with the counties within those. So in New York, if the person asking that question, on the island, it's not terrible. And just like anything else, the 5 boroughs are painful. Manhattan actually is known to be a pretty good one throughout the state, only because they put the resources towards it. So Manhattan's also actually not that bad, but Queens is god awful. So I'm going to stay on trust for one more second, if you don't mind, Rob. You can put up the box, not a big deal. But in turn, there's also irrevocable trusts, and irrevocable trusts are, like the name indicates, are irrevocable. They are not changeable or amendable. There's certain exceptions, but ignoring that. So why would you use an irrevocable trust? There's 2 main reasons why an individual that's joining us today that might use an irrevocable trust. One would be Medicaid planning. I don't think that's not within the purview of what we're discussing today, but there are a lot of families that are trying to look destitute on paper, not controlling the assets, get them out of their name, and apply for Medicaid. So that's a huge reason why someone might use an irrevocable trust. The other one is on the other end of the spectrum, and when we talk about estate tax planning or death tax planning. All right. So just again, give you a high level trust. There's revocable, irrevocable. Some are created during your lifetime. I'm able to create a trust for the benefit of Jeff and Rob. All right. With Mary as my trustee. Or I could stick it inside my last will and testament. So, for example, if something were to happen to my wife and I, my assets go to a trust for the benefit of my son, Christian. All right. Because 21-year-old males are going to make terrible decisions. So we lock it up away from him. He gets access to it. And so that's a different type of trust that's created inside the will. All right, so we'll go to another document that covers those 2 first documents, trust and last will and testament, that cover your beginning part of an estate plan. The next couple of boxes are going to be referring to ancillary documents. They have a couple different names, but ancillary documents. The first one is a durable power of attorney, and it is a very, very powerful document. It allows someone to step in your stead for anything else except healthcare decisions. There's 2 main types. The first one is a durable general power of attorney. The moment I sign it, I'm giving someone else the power to act in my best interests. The second type would be a springing power of attorney, where it says they don't get that power until I am mentally incapacitated. So those are the 2 main types. One that's immediate, and one that's going to come into effect when I'm mentally incapacitated. All right. Give you a good example and a bad example of why someone might have a durable power of attorney. The first one would be if I want to give, I'll just keep using my own family. If I want to give Jen the power, my wife, the power to access my bank account or call my 401k or access my social media when I'm mentally incapacitated, she'd be able to do that. And that's usually the main reason why for marriage to long duration. Not every couple gets it though, and not every individual gets one, but they are something you should know about and at least be offered by your attorney. Next one is a healthcare directive. Healthcare directive allows the world to know what you want to happen inside a vegetative state. If you have a permanent vegetative state and no one believes you're going to wake up, some clients will say, hey, I don't want to live that way. Let's just pull the plug. And it's a crude way of putting it, but it's real life. There's another subset of individuals and clients that will say, whoa, I don't know what's on that other side. You keep me alive as long as possible. And the idea when you create a healthcare directive is letting the world know what you want to happen. Not me, not your drafting attorney, literally just what you want to happen. Also within healthcare directives, you often see a healthcare proxy. Who's going to make medical decisions for you if you can't? Not overriding you. It's not going co like a durable power of attorney. It's you're in a car accident. Who's going to make those medical decisions? Often it's a spouse or a child. But what if you have multiple children? Who's the doctor supposed to listen to? So they would probably, so a healthcare proxy allows you to appoint somebody and put them in order. Next one. Beneficiary designation. While not truly a part of drafting for an attorney on a comprehensive estate plan, they become very, very important. A beneficiary designation is going to supersede a last will and testament or a trust even. So who you name becomes looking up who you named 10 years ago when you maybe started the 401k or had the life insurance becomes part of the actual plan when you do a comprehensive estate plan. You're going to need to know who does it. So I'll give you an easy example. There's a very, very famous case in my world where someone named their ex-wife on a 401k, went all the way to the Supreme Court. And the Supreme Court said, you had 20 years to fix this. I'm not just removing that person and putting in the new wife. Doesn't work that way for 401ks. IRAs, life insurance, it comes down to state rules, but for a 401k, you're going to want to know the beneficiary designation. Letter of intent. This provides instructions to your family, your executor who's just in charge of following your instructions. Beneficiaries, what your wishes, wanted, including funeral arrangements. Maybe you have a particular subset of religious beliefs that should follow how you want your burial handled, your cremation, your even just anything down to, in other states other than New York, where do you want your personal assets? Many women, even a lot of guys now, have a bunch of jewelry that they want to give away to specific people. You would provide that in your letter of intent. I mentioned this earlier, guardianship designations. There's going to be two that often come up when you do a comprehensive plan. The first one is inside your last will and testament. And again, that says, who do I want taking care of my children should me and my spouse predecease? Very, very important. And if you're taking care of other loved ones, maybe you're already a guardian of somebody else. And who do you want that person to go to? Next one is, I'm sorry, I'm going back to guardianship designation. The other one you might want to provide, especially if you're older and single, is who is going to take care of me? I'm not going to be there to tell the court who I want taking care of me if should I become mentally incapacitated. I have the moment, I have the ability to say, this is the person I want to take care of me should I become mentally incapacitated. And the last part of comprehensive estate planning is tax planning strategies. I think it's beyond the scope, other than a few examples I'm going to go into and how we plan for it, but there's really a couple of numbers you should know. One is the state exemption amount. And again, I know people are from all over the country, so I don't want to get too deep, and I keep giving New York examples because that's where I naturally land. But in New York, if you're north of about $7 million or so, you got to talk about planning for that. Because in New York, it's about an effective 10% estate tax or death tax, if you wish, just for the pleasure of living in this state.
And sorry to interrupt, but we do have several people that are not from New York. As far as California, Georgia,
sure,
Carolina.
Yeah.
So yeah, let's give those folks a break on the New York side because I don't think they like
very fair
up here. So.
You know what? As a potential segue, I think it's a good point to mention that the next topic at our next webinar is actually specifically around this type of planning. It's building your estate plan, strategies for wealth preservation. So, in respect of everyone's time and trying to get through this, to be able to answer questions, I think you've done a great job explaining everything. But I think what we should do is let people come tune into the next seminar, and we'll do this in much more detail.
Works for me. Just the other number I want to bring up,
Mm-hmm.
north of 14 million. I
you,
got to stick that in there. If you are north of $14 million, there is a federal estate tax for the pleasure of dying in our country, and it is punitive. It is nasty. It's about 40%. So it is
that is obviously going to possibly change for the worse, and by the end of the year, if Congress doesn't do anything. So yes, we'll cover that in the next topic too. So
will do. So that's all parts of a comprehensive estate tax plan, or estate plan. Should you have these documents already created, what you're looking at is thinking, did I answer those questions? When I created them, did my life change a little bit? Maybe this is off a little bit. And so always reach out to Rob and Jeff and Mary, and we can always review those documents for you.
Thank you, Evan. Now, let me ask you a question. Let's just say after everyone's listened to everything you say, they're still not moved to acting and getting a estate plan in place for themselves and their loved one. Would you be able to tell us what are some of the consequences of not having an estate plan in place?
All right. So when you don't have an estate plan given to you, the state where you live in gives you your plan. All right. So some states will say 50% to a surviving spouse, the other 50% to a child. Some might say everything to a surviving spouse and nothing to children. Some states take care of, some states will give you, if you have children from a previous marriage. So that all world is called intestacy, but it goes beyond that. So I'll give you an easy example here. So you forget about how the state applies that distribution schedule, even within your own life, you have to look at it. So everyone knows this family. This might be your family. We've got my son-in-law, Chad. That's all right. Can you go to the next slide?
Nope, I'm sorry.
That's all right. So we have our son-in-law, Chad, who goes by Chaz. Never worked a day in your business. He's never even walked into the office, but I bet he believes that he could run it better than you. Drives a $2,000 a month BMW, you pay the credit card bill. Zero is saved for your grandchild's education. He's married to your daughter, who you love a lot, but she currently believes that being an Instagram model is an actual employment. Doesn't have a checking account and still is on your family cell phone plan. Could be anyone's family, might be gradations of this. When you do not have an estate plan, and they leave assets to your children, it comes to your children outright if they're over the age of majority. All right. That is more often than not, this scares clients if they have children, especially if that child is married and you do not trust your in-laws. For me, that's usually if the child is above majority, because guardianships always go number one. This is number two. Hey, wait a minute. I'm going to leave this to my child. They're either going to blow it or they're going to get divorced because I know it's good money after bad. And the spouse may receive assets. So protecting the legacy that you built is important. And it doesn't matter the size. It's the legacy you worked hard for and built. You need to make sure it goes down accordingly to your plan, not theirs.
If I may, I'll just jump in and piggyback on those statements. You know, as much as we meet with people, although these characters are fiction, there are real examples that we run into very often that are very similar to this, right? And it's a really big concern for a lot of people that asset protection is part of one of the biggest concerns. And, estate planning addresses a lot of these things. So Evan, thank you so much about it, for adding this.
Jeff, maybe you can answer this, being the managing partner. One of the people asked that the information he's truly enjoying, but how does someone like the legacy group, like us, how is it that we differentiate ourselves from someone trying to use AI now and just asking estate planning questions to an AI program? What are the downsides to using these types of tools?
Like the legal writing tools? Is that what you mean, Gary?
Yeah, like a legal Zoom. Yeah, that's.
I don't mean to interrupt, Jeff. Do you want to answer, or should I?
Was that question for me? I'm sorry. I kind of.
Well, it's
either one.
Okay,
sorry.
I'll jump in.
Yeah, go ahead.
Okay. Talking a lot anyway. For me, I think I don't know if they're AI tools, but LegalZoom is the easiest example and kind of leads you down the questionnaire. I think a lot of times is not knowing what you don't know. And so a lot of those form-like answers or even AI can provide you with information if you have a baseline understanding. I'll give you an easy example. If you're using one of those tools and you have a child with special needs, all right, I'm just going to make up an example. Then they might, and I'll give you 2 examples or 3 examples, but the easy example of special needs would be if the system doesn't prompt you to understand the need, the Medicaid planning for that child, They might not prompt you to a third-party special needs trust. Another easy example, if someone said, hey, how long do you want to protect your child for? And you say, I don't know, majority. You might not know that you could protect him or her from their own assets, because money can do good things and money can do bad, for their entire lifetime. So while I think there is a place for them in law, I don't know if creating the initial estate plan would be it.
Yeah.
Just my
And
opinion.
I'll also add, again, from the financial planning perspective, and the question was specifically, how does the legacy group help in lieu of one of these things, right? So, we are a financial planning organization. We're not lawyers, right? And we although have Evan on our team, the process that we take you through, that we take our clients through, is one, to understand what actual type of planning you need. So whether it's basic estate planning or advanced estate planning, our goal is always first to educate our client, right? And with that comes understanding the type of will or estate planning you might need. So sometimes LegalZoom might be just right if your estate is very, very simple and it requires just, having a will is better than having no will at all. So if the budget constraints on having to pay, us for our services, an attorney for their services, I will tell you, I'll reference back one of the first comments I made at the very beginning is in spite of having advisors and having people that can do the work for you, such as attorneys or accountants, oftentimes, it's the process that they take you through that it's part of the problem, right? Because you don't know what you don't know, and sometimes you don't know the questions to ask. There will be some level of frustration and confusion. Just the other day, we had a couple in here who came to us and had done planning 4 years ago, but after reviewing what they had done, we realized that they, although had very nicely drafted documents and they overpaid for them, they actually didn't do any estate planning at all because nothing was moved into the trust. So the biggest difference that we bring to the table is that not only do we help you establish the trust or design the plan, but we also help you in the implementation. That does not mean drafting. We want to make sure that whoever you work with, attorney, whether it's a friend or an estate, planning attorney, is that what you want to happen and what actually will happen are one and the same. We're the quarterbacks that ensures that your planning is as it's supposed to be, not just a mere guess by using an AI tool. So sorry for the long-winded answer, but that I understand that that's what you were asking.
Thank you, Jeff. Mary, I'm going to go to you, and I hate to stifle your passion and your fire, but due to some time constraints, would you quickly be able to go through some key consequences, that people may have in terms of lack of planning?
Yeah, no problem. We've touched on a couple of these already, but probate delays and costs, and yeah, without a will or a trust, your estate must go through the probate process. And as Evan mentioned earlier, it really depends on whether that, even if you have a simple estate, it just depends on how long the court's going to take. And there's only so much. I can call the clerk a million times. That doesn't make them put your file to the top of the list. And so there's really nothing we can do once the petition is submitted. There's the unintended distribution of assets. State intestacy laws will determine who inherits your property. I had a client who came to me. She needed to do an administration proceeding for her father, which is when the person passes without an estate plan. She sat down and she told me, I took care of my dad my whole life, me and my husband. He wanted me to have the house. He wanted me to have whatever's in the bank accounts. And I have an estranged brother. What can we do? Because this is what my dad wanted. And I had to say, I'm sorry, in New York, because you're both his children, you get 50-50. It doesn't matter if he wasn't there. It doesn't matter if he didn't help. And so you don't want to put yourself in a position where that's your children or your circumstance. Then there's also higher taxes and administrative fees without certain strategic planning. Depending on the value of your estate, especially, your assets may lose significant value to taxes, court filing fees, or multiple legal proceedings, reducing what your loved ones actually receive, which isn't what you want them to receive the benefits of the legacy that you created. At least most people do. And it can create some financial hardship on your loved ones. It might prevent them from getting legal access to your accounts, bills go unpaid. Sometimes homes can't be refinanced, as I mentioned earlier. And then certain urgent decisions might get stalled. For example, when a surviving spouse gets blocked because there's no power of attorney in place, and now certain very important things that they need to do for themselves, for your children, and for you are temporarily put on hold. And then also there's family disputes. I was going to touch on this a little bit earlier with having the right conversation. So when there's no clear plan and no shared understanding, families often struggle with unspoken expectations, differing opinions, and old emotional wounds sometimes resurface under pressure. So I found that even the most loving families that have a solid foundation can find themselves in conflict and sometimes even litigation simply because no one told them what was supposed to happen. And a lot of the times I see the attitude of, one of the most common things I hear a lot is, my family will figure it out. But here's the reality: when something happens, when you're gone or you're no longer able to speak for yourself, grief doesn't often create clarity. It often creates pressure. And then people are suddenly juggling logistics, medical or financial decisions, and emotional stress, and sometimes even trauma that they don't have an opportunity to fully process. And even the most capable individuals can feel overwhelmed in a crisis. Even the most loving families can find themselves uncertain, in conflict, or simply unable to agree. And that miscommunication or lack of direction can really cause a lot of delays, disagreements, and like long-term damage. And then I will say also, loss of control over medical and financial decisions is a huge one, because this isn't even about you not being here anymore or this person not being here anymore. You're still alive, you've just become incapacitated. And if there's no power of attorney or healthcare directives in place, a court may appoint someone to make those decisions for you, and you want to be able to make those decisions for yourself.
Thank you.
Thanks.
Evan, earlier you brought up Chaz and Penny, and while they were created, I think it painted a great picture, but perhaps you can share some real life instances with some people that our audience might be familiar with.
Sure. There is no shortage of our society's obsession with celebrities, especially when they pass. So I chose two for this because I thought would be interesting. But even beyond these two, you can check out just Michael Jackson. They're just all over the place.
Friends.
The first one, I just finished rewatching season one, was James Gandolfini. So when he died, it was worth approximately $70 million. It pays well to be Tony. He died with a 17-page will. All right. For example, and Gary brought up like a legal Zoom. They're pushing out 17 pages worth of legal documents. So this was not a comprehensive plan by any stretch of the imagination. Not only was it not comprehensive, it was just completely tax inefficient. He left 20% to his most recent wife, and the remaining 80%, went to his sisters and his infant daughter. In addition, he gave his son, 13 at the time, the right of first refusal on the main residence. So you now have him trying to buy the house with insurance money that he didn't need to have come out of there, and it's 13 years old. So who's really making that decision anyway to actually buy or not buy the house? Are they kicking out the surviving spouse? The assets left to the infant daughter were distributable at 21 years old. So she is set to inherit whatever 80% is, minus how many families, tens of millions of dollars at the age of 21. It's unclear whether the 10% was the amount he wanted to actually even leave his son. So his son got less than his sisters. My guess, and it's a pure guess, has to do with that it was him sitting down with counsel, who was not a trust and estates counsel, or possibly doing it himself. We know he didn't, but it might have been better if he did it himself, and said, yeah, no, Larry, the aunts will take care of my son. I don't want to do it any other way. And just taxes be damned. So $70 million, he paid about 30 million in taxes that could have easily been avoided. And that's maybe even more than that. It's sad. And this is someone you would consider to have the best counsel, or at least access to the best counsel. Next example would be Philip Seymour Hoffman. Him and his girlfriend, longtime girlfriend, Mimi, they never got married. Then they had 3 children. At the time of his death, they were 5, 7, and 10. He died with an estate valued around $35 million. And his estate plan was created by his CPA. Never got sued. I looked up the list, but for some reason, a non-licensed attorney drew up the paperwork, maybe using software, maybe not. But I wouldn't, I shouldn't be doing your income taxes, and my CPA shouldn't be writing up your estate plan either, especially if you fall above those lines that we talked about earlier, that $14 million, especially. Since Hoffman and Mimi were not married, they didn't have the unlimited marital deduction. The unlimited marital deduction says that I can leave everything to my spouse, value be damned, without incurring an estate tax. Maybe he would have gotten married because of it, maybe he wouldn't, but that not being married left $12 million of estate taxes owed by his estate. So let's say he was worth 35, he left about 1/3 of it went to the federal government. Again, who knows if he would have gotten married to avoid that. Unfortunately, he died, probably wasn't in his right mind to get estate taxes fixed up, since he died of a drug overdose. We also don't know if, since he left everything to Mimi and not in a trust, because he just left everything to her outright, there's a chance that Mimi gets remarried and the assets don't even hit his 3 children. So if you do have a second marriage, the reason I even bring this example up has to do with second marriages. So if you have a second marriage and you says husband to wife and then wife to children, if those children aren't the wife's, or vice versa, it doesn't matter, but aren't the wife's children, and her will says the same thing, it's not going to your kids. So you can inadvertently disinherit children. And that's, yeah, it didn't happen in this case. Last time I looked at this case, Mimi, who had a recent Vogue spread, because I was doing my research, is not remarried. So maybe it will go down to his 3 children. Any other, if there's a football fan, there's great, the Dolphins died without an estate plan. That was a disaster. That's why it was sold. There's just a million examples that there's books on it, but it's always fun to look them up.
Thank you, Evan. The next portion, Mary, I'm going to ask you to go through this relatively quickly because we are going over a little bit. The reason why I feel it's okay to sort of gloss over such a key topic is that, again, as I mentioned earlier, this is a series we're having over the summer, and the 4th webinar is going to dive into the next topic, which is having the essential conversation with your family and how to do so, how to ask the hard questions. So Mary, could you briefly go through the next part regarding family planning and having the conversation with our loved ones?
Sure. So estate planning isn't just about paperwork. Many of you are here because you already understand on some level how important planning is. And maybe you've tried to talk to a parent, a spouse, or a sibling, and they've shut you down. And so this is the part of the workshop where I'm just going to give you a little bit of a brief overview of what's to come. And so why these conversations feel hard is estate planning can feel like stepping into a minefield. It forces us to think about vulnerability, aging, illness, and mortality, and that's not fun for most people. I like to typically offer my clients a reframe, explaining to them that it's not about death, it's more about legacy, the story you want told, and the impact you want to leave, even if it's only within your own circle of people. And I found that many older adults resist these conversations because they fear losing control. And so starting with starting with, well, we're all going to die someday to your mom or dad is usually not the best move. And that's exactly what we're trying to avoid facing. And when you lead with fear, it tends to trigger more defensiveness. So a more helpful approach is usually empowering and reframing estate planning as a tool to protect their control. I find that adult children often hesitate because of fear or of role reversal or appearing opportunistic or causing distress to their parents. And it's not always easy to help a parent plan while also managing your emotions and maintaining trust with them. So, and it can even be harder when siblings are involved. Two siblings who generally get along can have completely different values, communication styles, or ideas of what's best for the parent. The love is there, but you just have different ideas. And so in the next workshop, we'll discuss, well, in a future workshop, we'll discuss more about how to approach these conversations as a team and make sure everyone feels seen and heard. And then estate planning can feel emotional, but I found that avoidance only increases the pressure later. And so we'll go through everything again at a future workshop. I don't want to take up too much time because I know we're running a little bit behind. So yeah.
I think that's a good segue into how to talk about, the tougher things when it comes to this planning and loved ones.
Yeah. So it starts, I think, by even understanding that it's not something that this isn't a single conversation. It's a series of conversations, and it's about asking the tough questions and figuring out your answers. And I'll really go into detail in the future about how best you can communicate your intentions and the values and your intentions and values to help give your family clarity and reduce emotional strain and ensure that your legacy is carried forward with purpose, or that theirs is. But really, I think by taking the time to communicate these intentions and values, we'll talk about it more in more detail in a future workshop. But that's a good way to start, is by acknowledging that it's not just a single conversation. This is going to be a series of conversations that you're going to have to repeatedly revisit.
And Mary, for those that may not be able to attend the next or that specific webinar on having this conversation, perhaps you can leave them with certain conversation starters or ways that they can initiate the conversation with their loved ones.
Yeah, so there are some really, for a little bit of context, there's first some perspectives of just understanding what that person values. So some people are very legacy based in mind, and you can say things like, what do you want people to remember you for? And estate planning is how you pass down your values, not just your things. Then for individuals who are more concerned about making sure that their family is protected, and that's where their values lie, there's things that you can say to them, like planning will help protect us from like any confusion, so we make sure that we know what you want, and that you can protect us in the way that have been protecting us your entire life. Other people they're very focused on, they have an idea of how they want themselves remembered and honored, and you can let them know, like, I just want to make sure that your wishes are taken care of in the exact way that you intended for them to be, and showing them that you value what they're prioritizing in their life, and that it's not about what you want, but truly making sure that what they want is honored. It typically helps people become a little bit more receptive and less defensive. And then there's a lot of people I find who just, no one likes feeling like they're not in control. And so reframing it to be more of, this will help keep you in charge by getting this financial POA, by getting this healthcare proxy. These documents are what keeps you in the driver's seat, maybe in a moment that you can't be. So yeah. And again, you don't need to convince anyone in just one conversation. It just starts the conversation. It helps them start thinking about it in a new way.
Thank you so much, Mary. Mary, Evan, I want to thank you both for everything you've said and all the great wisdom you've imparted on those that are with us. But I think one of the biggest things we want to leave everyone with, and maybe Evan, you can take this, is the people here have been moved. They created their plan. They're setting everything up to take care of their families. But why not tell them why it's best not to keep it a secret, and why they should share with those that are involved in their planning? and some of the benefits of that. So Evan, if you could just jump in, I'd greatly appreciate it. Looks like you muted yourself.
There you go. It's important to share because there's a couple of reasons. It's to avoid inter-family fighting. All right. That's the first step. There's no parent out there that wants their children to not speak upon your passing. And if you were to share your information with your children, again, we're not talking about 22-year-olds, but if they were mature enough to have that conversation, they should at least know what mom and dad want. Um, the other thing that helps with the planning process is especially important for those that are business owners or own different buildings. And so you might leave assets to certain children versus other people, charitable intent. It's really getting it out in the open so for people to talk about. Again, it's not right for every family because it might just break it down before you need to. But if your family's tight and you guys talk about those things anyway, you're going to want them to know where to find the documents and how to implement those documents. Okay. I don't want to keep anyone much longer, but
Evan, thank you so much. At this point, I'd like to hand it back over to Jeff to sort of close it out and answer whatever questions do come up.
So yeah, guys, thank you again. We do apologize for, going over a few minutes, but I think that, we did have a couple of good questions that, that were relevant to the topic that we're discussing. So I think the message to take away from today, it's all about having a conversation about what matters most, right? And, there's a few questions that are kind of the same, so I'll do my best to kind of answer all of them around what exactly is a typical process, right? And what do we do, and why is a financial planning firm like the Legacy Group promoting estate planning? Because we believe that in order to have a good, sound financial plan, everything has to be looked at on a three-dimensional planning process, right? And that's really something that we do with every client that comes through the door. So whether they're looking for investment advice or retirement planning advice or succession advice, because of the punitive tax laws that we have, we always have to consider what is the impact, what is the financial impact of the decisions that people are trying to make, right? So we're always, encouraging people to review their estate plan, to review their legal documents, to ensure that that what they want to happen is what actually does happen, right? And oftentimes we find coordination gaps in that plan, right? So, really we act as a fiduciary because we are fee-based planners, right? So what does that mean? What that means is that, when people meet with us, right, and first of all, the first consultation is obviously free to first identify whether or not there is something we can do to help, right? If we identify opportunities where we can be of service, we will certainly let you know, right? But there is no fee for the first consultation. From there, right, we're able to really identify where are the planning opportunities and what service we can provide you as an individual or family or a business owner. From that point, right, essentially what we do is design your financial plan or estate plan or a combination of the two. A lot of times, like I said, it's not one size fits all. Every client is different, and everybody has unique needs, which we will address throughout the first meeting. So with that, I want to thank everyone for attending, and again, encourage you to reach out to us. We will be.
Jeff, if I could just jump in real quick, I apologize. Two things. We did get a question regarding what typical costs are when it comes to estate planning in regards to implementing some of the strategies we discussed today. I know the answer is going to be somewhat ambiguous, but perhaps you can just touch upon that.
Sure, no problem. So yeah, it's a good question. Fees, right? It really is all dependent on the size and the complexity of the estate of the business, right? So the financial planning fee that you pay the Legacy Group has nothing to do with the actual implementation and the drafting of legal documents. Again, so again, if you have a very simple estate, and depending on the state where you actually live, you might find basic, simple estate planning that's going to range you somewhere in the vicinity of $3,500, maybe to $5,000 for a set of wills and directives. As your estate gets more complicated, right, you need trusts, whether there are for real estate or insurance or businesses, family limited partnerships. So those, obviously, if you're living in a state like California or New York or Florida, some of those legal fees are going to go, upwards of $20,000, $30,000, $40,000, $100,000, depending again on the situation. But again, that's not something that should prevent you from at least having the initial conversation with us, because the whole point of having us, right, having us go through the initial process is to help you identify and prepare you for what you should expect, from your advisors, from your attorney. And a lot of times you save money as a result of working through us, because we're there to guide you. We're there to not have you do unnecessary work and pay for things that you don't need. And we see a lot of that as people come through the office. And again, that sense of frustration. I don't understand what we did, and we paid them all this money, and yet I feel like I don't understand. Like, that's a very common theme that we hear from people. And believe it or not, those are people that have paid tens of thousands of dollars to their attorneys for very little actual planning. They have fancy documents written really well, but what does it actually do for your family, right? So that's what we're there for, to make sure that everyone is getting what they deserve. So last thing I will add is that, as a follow-up, we will be sending a copy of our estate planning guide, which is something that you can utilize to kind of reference back for good information and help you get started with your estate planning journey. So once again, thank you for joining us this afternoon, and we look forward to having you join us in our future webinars later in July. Thanks again. Have a good night.